So chapter 9 is our last chapter on contract law. Very briefly reviewing chapters 6 and 7, we learned about the 5 required elements for a valid contract: consensus, which is made of a valid offer and effective acceptance; consideration, the price to be paid; the mutual benefit; and then chapter 7, the 3 remaining required elements: capacity, which we saw some issues with minors, intoxicated or insane corporations, and others. And then we saw legality, 2 different aspects with regards to legality. One, when the contract is formed illegally, which is basically an illegal subject matter: drugs, prostitution, committing a crime, preventing competition, etc. And the other aspect with legality is when the contract is formed legally, however, performance of the contract is illegal. So I gave you the example of a regular person providing dentist services without being a dentist. So that's an illegal contract in terms of performance, because dentist service is a legal subject matter. However, only a dentist can provide such services. And the other example I gave you was related to a minor illegality in performance, such as the construction company is building your house. They have started, but they haven't acquired the permit yet. So this contract is usually legal. Courts, if needed, they would just require correction for that illegality. And the last aspect we saw, the last required element, was intention. And intention, pretty straightforward. Most contracts, intention is presumed. For business contracts, commercial contracts, intention is presumed. However, for family or social relationships, intention, there's a presumption of no intention. So I've given you the example about my selling my car to my daughter. It's a family relationship, so there's a presumption of no intention. However, such presumption may be rebutted. So if needed be, I could show the courts that my daughter needed a car, she paid a fair market value, and she also had the opportunity to seek independent legal advice. So the 5 required elements, chapter 7, we also saw the written form, written piece, just for some types of transactions, such as land transactions, contracts that are longer than 1 year. And then chapter 8, we saw some issues that take place with a contract. We saw misrepresentation, false statement. We saw the 3 types of misrepresentation, the remedies that are available. Rescission is available for all of them. However, damage is only for negligent and fraudulent misrepresentation. We also saw mistake. The most important for us is shared mistake, in which the subject matter disappears or is destroyed. We had this multiple choice question in the slides talking about the coal, the load of coal. The ship had sunk and the coal was lost, so the subject matter of the agreement was lost. This is a shared mistake because unknown to both parties, the coal was lost. So that's a shared mistake. We also saw duress, serious threat, could be physical, could be threat of firing, losing employment, any other illegal activities. And remember, a contract under duress is voidable, not void, is voidable, because the victim may decide to go ahead, may decide not to bother with that duress. But if the victim wants, they may cancel the agreement in court, claiming duress. We also saw undue influence, which is when one party exercises pressure, power, when one party abuses their trust. And there's a presumption of undue influence, again, in family and social relationships. So I told you, if a church leader enters into an agreement with a church follower, there's presumption of undue influence. But again, such presumption may be rebutted. Such presumption may be taken away if needed be. And we also saw unconscionable transaction. So it is a transaction in which the one I exemplified to you was my mom purchasing a smartphone and paying $10,000 for a 1,000 worth smartphone. So she's not technology savvy, and she thought 10,000 would be fair. No, she was taken advantage of. The agreement would still be legal, but courts would correct such agreement. Well, just very briefly summarizing what we saw last week, and now starting chapter 9. So what do we have in chapter 9? Now, the contract ends. So we learned how a contract is valid. We learned issues that may take place with a contract or during a contractual relationship. Now, how a contract ends. And a contract mainly ends by performance or by breach or by agreement between the parties or by frustration. And let me tell you right away, frustration is not the feeling you have now. Frustration is a legal concept I'm going to explain to you in a little while. And you can see in the slides, it says methods of discharging. So discharging is a technical term, which means terminating or ending a contract. So why do we use discharge, not terminate or not end? Well, we use all of them interchangeably. However, using technical words allow us lawyers to charge our clients more money. Okay, but just remember, discharging means terminating or ending a contract. So first of all, a contract ends by performance, and this is very straightforward. So you go to Starbucks, you buy yourself a latte, you pay for the latte, your obligation, and you get the latte. So Starbucks complied with their obligation. You got the latte as a benefit, they got the money as a benefit. So there was performance by both parties. Both parties satisfactorily completed their part of the bargain. So this is performance. The contract is ended. However, sometimes there's a minor issue with performance. We call this substantial performance. So let's say you ordered a latte and you wanted 1% milk, but they offered you 2% milk. And as long as you have no health issues with the 2% milk, well, they have substantially performed their part, even though they made a mistake. Yes, you have a right for an exchange, or to get a discount, but still they have completed with their part. Okay, or the example I'm giving you here in the slides. So you order 10,000 liters, but you only got 9,900 liters. So again, we say the contract was substantially performed, but you have a right for a discount or to claim the loss. Okay, I'll come back to this warranty, a minor term, in a while when we talk about discharge or termination by breach. Okay, so here, straightforward. We need to know what tender of performance is. Tender of performance is a legal concept which means when one party is ready, willing, and able to complete their part of the agreement, but the other party refuses. And this refusal could be for any reasons, could be for legal reasons, could be for illegal reasons. Let me give you this example. So I hired a gardener to come to my house 8 a.m., but then I left my house at 7 a.m. to go to work. There was no one at home. So the gardener arrived at my house, but no one, there was no one in here. So the gardener was ready, willing, and able to do the garden, to complete their part of the bargain. However, I was not here. So performance was refused. This is tender of performance. The gardener is aware that if they entered my property without proper authorization, the neighbors could call the police for trespassing, as you saw in chapter 4. So this is an example of tender of performance. And when this takes place, what is the consequence? The consequence is that the party that tried to perform but had performance refused, they are relieved from their obligations. They don't need to perform anymore. So the gardener, they may drive back home and they don't need to perform anymore. And the gardener can also sue for damages because the gardener drove all the way here, eventually rented machinery, hired hourly personnel to help with the garden. So they don't need to do the garden anymore, and still they can sue for damages if they have any. Okay, so that is tender of performance. But tender of performance does not apply exactly this way for payment, only for payment. So payment here is an exception. So if you need to pay someone, if your part of the contract is to pay and payment is refused, let's say it is refused because there was no one at home again, or because you tried to pay check, the person wanted cash, whatever the reason was. So when there's payment involved, then the amount is still owned. Okay, it doesn't. If it is an obligation, you are relieved, as I exemplify with the gardener, but not for payment. With payment, you still have to pay. But the difference is that because your attempt to pay was refused, then the creditor now needs to come to you to collect the money. You don't need to go to the creditor to pay again. Okay, so there's only one exception, and this exception is for payment. And when we talk about ending an agreement by performance, we just need to remember that some obligations, they continue after the contract. And the best example will be for consumer products. So you go to Best Buy, and by the way, disclaimer here, I'm not sponsored by Best Buy, but just as an example. So you go to Best Buy and you buy yourself a new laptop, and then you pay, they deliver you the laptop. So all obligations were performed, the contract is ended. However, when you get home, and for 7 days or 30 days or for some time, if there are any issues with your laptop, not functioning well, there was some scratches on the screen or anything else, you still have the right, and Best Buy still has an obligation to either fix or replace with a new one. So even though there was performance by both sides, there were still some obligations that survived the contract. Okay, and again, the best example is for consumer transactions. Are we good so far? Okay, so question for you. And you're seeing the answer key was showing to you, so hopefully it's not anymore. Okay, all those here are wrong except one. Okay, B. B is the right one. B is the true one. So what happened in B? How do we call this in B? The person attempted to perform, but performance was refused. So the buyer, the person attempting to perform can sue the buyer and no further attempt to perform. How do we call this? Just explained. Okay, if you thought of tender of performance, you are right. So letter B is another example of tender of performance. I will not explain D for now. So warranty, I will explain just in the next slides, and then I'll come back to this statement here to talk about it with you. Any questions on C or A? Okay, so question here, tender is a refused action. Yes, is an attempt. The action done by the person that will have satisfied their obligation. Yeah, actually they try to satisfy their obligation under the contract, but there was refusal for any reasons. So that obligation is now doesn't exist anymore. So the person is now relieved from their obligation because they try to perform. Okay, does it make sense? All right. Okay, so moving on. So first, um, first way to end a contract we learned was by performance. Now by breach. So a contract ends by breach. A contract may end when there's a breach. And what is a breach? A breach of contract is when performance is either improper or incomplete. But it cannot be substantially, it has to be substantially incomplete. Remember we saw here about substantial performance. So incompletion, it was in a minor way incomplete. So this is substantial performance. But if it's in a major way, then we have a breach. So a breach is when performance is either improper or incomplete. So you order coffee and you get tea. So that's improper performance. Or you order large coffee and you get a small one and you paid for the large one. So that's also incomplete. There's a breach. And there's also refusal to perform. See here, we just talked about tender of performance, and this is refusal to receive the obligations under a contract. But now, breach is refusal to perform. So I hire the gardener to come, and the gardener calls me or doesn't bother to call me and doesn't come. So there was refusal to perform. Okay, so let's see details about breach of contract. And by the way, most lawsuits in contract law, they are related to breach of contract because one party either performed improperly or in an incomplete way, and then the other party sues that party. So we need to learn two concepts. One is condition, the other is warranty. And warranty here is not a synonym of guarantee. Warranty here is a legal contract term. So condition is an essential term, is a major term. So whenever I refer to a condition in a contract, I am referring to a major term. So if you buy, let's say you want to buy a Tesla Model S, and then the Tesla dealership delivers you a Tesla Model 3. You didn't get what you ordered. So there was a major breach. You ordered Model S over 100,000, and they try to deliver you a Model 3 about 70,000. So it means they breached a condition, a major term. And why do we need to know this? Because whenever a breach is related to a major term, the victim of the breach is relieved from their obligations. So last Saturday, I ordered this Tesla Model S, and then I went to take delivery. They wanted to deliver me the Model 3. So they breached in a major term the agreement. I was relieved to buy that car that I didn't order, and I got my money back. You ordered coffee at Starbucks or Timmy's, and they give you tea. No, you don't need to pay for that because they breached a major term. Warranty, on the other hand, is a minor term. And a minor term would be, let me give you this example. So you order a white Model S, and they deliver you a black Model S with all the other features. It's the same car, only the color is different. So when a minor term, because the car is still brand new and everything, so when a minor term is breached, when a warranty is breached, the victim is not relieved from their obligation. They still have to go ahead with the deal. So I would need to buy that black car, even though I had ordered a white one. Okay? Because here was a minor thing. So you ordered, let's say, black coffee, strong coffee, and they gave you a blonde coffee. So here it would be in principle, a warranty that was breached. What is very important here again is the consequence. When a major term, in other words, condition, is breached, the victim is relieved. However, when a warranty or a minor term is breached, the victim is not relieved, but they may sue for losses or damages or discounts or whatever they are. Okay? Exemption clauses. You already saw this a little bit in Chapter 6. Just remember that an exemption clause is a clause that tries to limit or eliminate the liability of one party. A good example here would be, so again, you go to Best Buy to buy your laptop and you see one on display. That one on display, they are offering you a 20% discount because there may be some minor scratches on the screen, the keyboard is dirty, but still the laptop is working properly. So they let you know, they bring to your attention, because they have to, that they will not accept complaints about minor scratches on the screen or dirty keyboard because they have this exemption. They are giving you a discount, but they are letting you know display item final sale, 20% discount for minor scratches and dirty keyboard. So this is an example of an exemption clause. However, they are only valid if they are brought to your attention before you enter into the agreement. It cannot be brought to your attention after. Fundamental breach is just literally the way it reads. So it is a breach of a condition, a breach of a major term, because what you bargain for, you don't get. So that's what a fundamental breach is, just emphasizing. And there's also breach, as I said, by refusal to perform. And a synonym for that, a legal terminology for this is also repudiation. So remember, I hired a gardener to come and the gardener didn't come. So that's refusal to perform. But there's one type of refusal to perform that is important to us. It is the anticipatory breach. It is when the refusal takes place before performance is due. So the gardener should have come at 8 a.m. this morning. But yesterday night, the gardener called me and said, hey, I cannot come tomorrow for whatever reasons. So the gardener's obligation was due this morning, but one day before, the gardener called me to say they would not perform. This is anticipatory breach. Why is this important? Because the victim has two options, but it's going to be either one or the other. And when you make your choice, that choice is binding. You cannot change. So when you are a victim of anticipatory breach, you can either accept the anticipatory breach and you may sue for damages if you incur any damages. If you don't incur any damages, it's fine. Just let it go. Or you can insist on performance. And insist on performance is not going to the gardener's house, knocking on their door and say, hey, you need to come to my house. No. This is going to court and insisting on performance because you don't want damages. Let me give you another example. So I have a coffee shop and I have a supplier that supplies me fresh baked croissants every morning. And we have a 5-year contract. So my supplier stops supplying me. Could be for a legal reason or illegal. The reason doesn't matter here. But the fact is that the supplier stops supplying me. So I may go to court and I say, hey, court, I don't want money. I want the supplier to keep on performing their obligations, which are delivering me the fresh baked croissants. So this is insisting on performance, going to court and suing for performance to keep on. Okay. So here you have just a chart summarizing this, and now a question for you. So which one is correct or true here? Yes, that's correct. A is the correct one. When a condition is breached, when a major term is breached, the victim is relieved from their obligations. The contract is ended. Yeah, A is the correct one. Let me just go back to that one. The other one, I told you I was going to tell you about warranty. So here we were looking for the true one. And D is saying if a warranty is breached, the victim has no further obligation. No, that is wrong. If a condition is breached, remember, if a warranty is breached, the victim has further obligation to perform. The victim has to perform. So that's why D was not correct here. And, here, sorry. And yes, you're right. A is the correct answer. So B is saying when condition is breached, the person can only sue but must perform. No, this is wrong. This is a warranty. When a warranty is breached, the victim can treat the contract. No, that's wrong. When a contract for the purchase of goods is breached, the warranty, no, warranty here is trying to confuse you with guarantee. They are not related here in this context. And E, when a contract is repudiated, what is repudiated? When there's refusal to perform before performance is due. So anticipatory breach, this means anticipatory breach. The victim must wait until performance before taking any action. No. I told you that when there's anticipatory breach, you can choose the repudiation or insist on performance. And you don't need to wait for performance to be due. Okay? So moving on. So the third way a contract may end is by agreement. Well, this is straightforward. Two parties have an agreement, and then they sit together to agree to terminate the agreement or to modify an agreement. Well, let's say I have an agreement with BCIT as a faculty, and then I get an offer to go teach in Hawaii, and then I'm interested in going to Hawaii to teach there. So I'll come to BCIT, and we will discuss an agreement to terminate our current agreement. Okay, so that is an example of an agreement terminating by another agreement. But this another agreement may terminate an agreement or may modify. Let's say we have an agreement for me to teach law courses, but now they also want me to teach, let's say, organizational behavior. So we may sit and agree to modify our current agreement. Okay, so this is when an example of when a contract ends by agreement. I'm showing you here unilateral discharge. So when one party does not perform their agreement. So let's say I got this job offer to go to Hawaii, and then decide to go. I just call BCH and I say, hey, I'm going to Hawaii, thank you, bye. No, this is one-sided discharge. We are not agreeing. I'm just letting them know this is actually a breach. I am breaching because I'm not performing. I'm not delivering the lectures I was supposed to because I just went away, traveled to Hawaii. So this is not an agreement when it is one-sided. We have this concept of accord and satisfaction. This is when parties, let's say they have a loan agreement, and then the debtor has defaulted payment, and the creditor says, "Hey, I'll give you a discount if you pay me, if you can pay me now." So let's say the debtor owned 1,000. The creditor said, "Hey, if you have 500, it's okay. I'll get it." Well, the creditor actually is getting less than they agreed. In principle, this would not be valid consideration. However, in law, we have this accord and satisfaction, which means there's still a benefit because the creditor would not get paid anything because there was a default. So now the creditor is getting at least 500. So we call this accord and satisfaction. So parties, they make a settlement. They agree to settle a dispute or an issue they have. Example, as I gave you here, paying less to satisfy a debt. Novation. So I told you last week I would talk about novation today. So novation is when there's a new party to an agreement. Well, remember last week I told you that when we discussed privity of contract, this concept that says that a contract only affects the parties to it, I told you that there were some exceptions, and one of the exceptions was that contract rights, they run with the land. So I told you that if you rent a house and the landlord sells the house, you are still renting the house. However, you have a new landlord because there's now a buyer, so a new owner of the house. So the new owner is now your new landlord, and in law, we say there was novation in your tenancy agreement. Why novation? Because the old owner of the house, your old landlord, is now replaced by the new owner of the house or your new landlord. So this is novation, when one of the original parties is replaced by another one. So it means that, why do we say novation is a type of discharge by agreement? Because for your old landlord, the contract was ended. They are not part of the contract anymore. Now it is the new landlord that is part of the agreement. So, question for you. So question here, what about the terms of the new novation? Does that change? No, in principle not. When there's novation, only the party is replaced. There's only a replacement of the party. The other terms of the agreement, they remain the same. So in all examples here, the contract is ended, except in one. Which one is this exception? Which one is this event that does not end the agreement here? C. Actually not. In C, we have frustration, and I will explain to you in a minute. Because here, building a model was agreed on 10, but the model was destroyed on March 9. So this is frustration. But I'll tell you in a minute. D, Fred no longer wants to honor his contract to sell Mitra his printer, but tells Mitra he'll substitute a 500 volt. Mitra agrees. No, actually, in D, the contract ends. Why? Because Mitra agrees on on getting 500 a 500 volt instead of a printer. So there's an agreement here to change an agreement. A, the buyer and seller agree orally to cancel their contract when neither one has performed their obligations. Well, no one had performed obligations, so no one is owning anyone. And the fact that they agreed orally, it doesn't make a negative difference in here. Remember that oral agreements, they are as valid as written ones. So here, yes, the contract ends. So the only one in which the contract doesn't end is in E. When Ben's new car is delivered, the seats are cloth rather than leather as ordered. So the seats are cloth, but they were ordered as leather. But the seats are still there. The car is still the one that Ben had ordered. So here there was a breach of warranty, not condition. And remember, when a warranty is breached, the contract is not ended. Parties have to go ahead with the deal. So the right answer is E. Okay? Because a minor obligation, minor term was breached. All right, moving on. So we need to learn about those two concepts, condition precedent and condition subsequent. So condition precedent, you also saw in chapter 6, just reviewing here. This is a condition. A condition has to be met before the contract starts. That's why it is called condition precedent, before. So the example here is, I will buy your car if I sell mine. So we don't have an agreement for me to buy your car until I sell my car. But after I sell my car, then this condition, this pre-existing condition is met. Then I have to buy your car. Another example we have in real life. I will buy this house if I can secure mortgage at a bank. So if I don't secure mortgage at a bank, we don't have an agreement for me to buy your house. But if I do secure the mortgage, then our agreement starts. So that's the condition precedent. And now we have the condition subsequent, after. So a condition subsequent is a condition that ends an agreement. It is an event that ends an agreement. So I have an agreement with my daughter that I will pay her $10 per month until she graduates. So her graduation is a condition subsequent because when she graduates, the contract will be ended. Okay? So it's a condition in the future that will end the agreement. So you need to understand conditions precedent and subsequent. One, precedent starts the agreement. Subsequent ends the agreement. Well, force majeure. Force majeure, and sorry for my French expression, French pronunciation. Force majeure is a clause in which parties agree that if certain events take place, they will renegotiate the contract. By the way, now with COVID-19, many contracts with a force majeure clause, they are being renegotiated. So companies are trying not to pay rent or to have a discount or to deliver goods or to manufacture. So when certain events take place, but those events, they have to be agreed upon in the contract. So in the contract, there will be a force majeure clause. And why am I saying this? Because force majeure is different from frustration that I will explain to you just now. Frustration is this outside and unforeseen event. And when this unforeseen and outside event takes place, performance is impossible. Again, COVID-19 may have frustrated a lot of agreements. So I have a small shop. Because of COVID-19, my shop is closed. So I cannot offer workplace to my employees. So it means the employment agreement was frustrated. This was not anticipated. This was not caused by me or by my employee. This was caused from an outside unforeseen situation and cause. And again, the consequence is that performance is impossible. So there may be both frustration and force majeure events taking place now because of COVID-19. But frustration, remember, is outside, is unforeseen. Whereas force majeure, it is foreseen because parties will agree upon certain events, such as acts of gods, strikes, hurricanes, wars. Those are more related to force majeure when they are detailed in the contract. So, frustration cannot be confused with shared mistake. So remember shared mistake. I sell you my car, but unknown to both of us, my car was destroyed in the parking lot. My car was stolen. So this is shared mistake. Frustration and shared mistake takes place when or before the contract is formed, because unknown to both parties, my car was destroyed. Whereas frustration takes place after the contract is ended. So I sold you my car. I would deliver the car to you this morning, but a tree in my garden fell and destroyed the car. So this is frustration because the tree falling in my car is unforeseen, is outside. I didn't cause this. Okay, so we cannot confuse. We have to be able to differentiate frustration from shared mistake. Okay. Moving on. So yeah, just here detailing frustration. And one important aspect is that with frustration, the event that caused performance to be impossible must be unanticipated, because if it is anticipated, it will be force majeure. So parties will then discuss what they will do. Another example, let's say an employee, unfortunately, is affected by a terminal illness, so the employment agreement will be frustrated. The employee didn't cause that, the employer didn't cause that, so there will be frustration there. Okay, another example. So here's detailing a bit more, and now a question for you with regards to frustration. So the question you have to ask yourself here is, which circumstance here was outside, was unforeseen? Because if it was caused by one of the parties, or if it could be anticipated, then it is not frustration. So that's the question you have to ask yourself in here. Yeah, exactly. B, that's B. So the convention was canceled because of an epidemic. Yeah, this is unforeseen. This is outside. All other examples, well, in number one is actually the tomato crop was destroyed because of hail. Well, if you are in the farm business, you should anticipate that hail could take place. And yet, the crop was destroyed a few days before. So you could still get supply of tomatoes with someone else. So here performance could be more difficult, but still not impossible. B, yes, impossible. So yes, frustration. C, Moore, the sculptor, while he was driving, he had drunk before. So it was probably his negligence here, not frustration. In D, there was a loss in stock market. Well, it is foreseeable that when you are investing in stock market, you may lose money. So not frustration here. And E, the horse was dead when they entered into the agreement. So here is shared mistake, not frustration in E. So yes, B is the correct answer. All right, so now let's talk about remedies for contract. And this shouldn't take long, and then I'll stop for a break. So you already saw those in chapter 3, and also you saw remedies in tort law. There will be some specific details for contract law here, but the general concepts are similar. So what are damages? Damages are monetary compensation. However, in contract law, when you sue for damages, you are actually suing because the contract was breached, so performance was not there. So the damages in contract law, they will look to the future. Why? So what advantage, could be financial, what advantage would I would have had if the contract had been properly performed? So this is how courts will look at damages. They will look at the future. They will look forward. They will consider what benefit would the victim have gotten if the contract had been properly performed, and then they will estimate the damages. And this is different from torts in chapters 4 and 5, because in torts, so let's say you suffered a car accident and your car was damaged. So in tort, damages, they will look at the past. They will look backwards. Why? Because damages will be used to put your car in the condition it was before the tort took place. So damages in tort law will function as fixing what was damaged. And in contract law, will function as compensating as if the contract had been performed. So this is important for you to know. You know the types of damages, so special, general, and punitive damages, just reviewing here. And there are some limitations to recover damages. Well, the first limitation is related to remotedness. The person claiming for damages cannot be so remote. So let's say I have a shop, my coffee shop, and then my fresh croissant supplier did not supply the fresh croissants. And because I didn't have fresh croissants this morning, one of my clients could not have croissants for their coffee break. But the supplier of fresh croissants cannot be forced to pay damages to my client. So remotedness is this: only the foreseeable damages will be compensated. So it is foreseeable that I, the coffee shop owner, will have damages, but for the fresh croissant suppliers. But it's not foreseeable for the supplier that my clients will have damages. So this would be too remote. And in this case, there wouldn't be damages. And also mitigation. Mitigation, so victims of contract law, they have to mitigate their loss, or at least try. So again, in my example, I didn't get the fresh croissants this morning. So I cannot fold my arms and watch Netflix for the whole morning. I have to go out there and try to find other suppliers for fresh croissants, at least for today, so that I could mitigate my loss as much as possible. I don't have the obligation to get the croissants, but at least I have to try getting them. So I would show the court I try to mitigate my loss. What else? We have the acceleration clause. What is this? This is a clause in an agreement, in a loan agreement, that says if you default a payment, usually for finance cars, leased cars, even mortgages, if you default, sometimes one payment, 5, 6 payments, depending on the agreement, the whole outstanding debt becomes due immediately, due and payable immediately. So in real life, whenever you're signing a loan agreement, make sure you know if there's an acceleration clause or not, because if there is one, you cannot default payment. If you default payment, the creditor will come to you and require you to pay the outstanding debt immediately. Okay? The liquidated damages, this is a clause in which parties agree that if one party breaches the agreement, the other is entitled to some damages, regardless if the victim had damages or not. This is very common with, let's say, sports athletes. Let's say this athlete is sponsored by Nike, and there's a liquidated damage clause in their agreement, which says if the athlete wears any sportswear that is not Nike, they will have to pay $500,000, $1 million, thousands of dollars. So regardless if Nike had the damages or not, but because they have this liquidated damages, as long as one party breached the agreement, the other is entitled to that compensation. Deposit and down payment. This is very interesting. Mainly if you're buying a car. So when you're buying a car, if you pay a deposit and you change your mind, you don't get the deposit back. So the deposit is always forfeited. However, a down payment is not. So if you are buying a car and you are not required to make a deposit, but just a down payment, and then you change your mind, then you can get your down payment back. So real life application is whenever you pay a deposit, the other party is trying to make you not to change your mind, because if you do change your mind for that transaction, you will not get the money back. Okay. Equitable remedies also coming from chapter 3, just reviewing here. Rescission we already saw. It is when the contract is canceled, parties are restored to their original position. Rectification, we also saw last week, when the courts correct any wording. However, remember, mistake, the error or mistake has to be obvious, or the courts will apply the reasonable person test, but courts will usually not rewrite the agreement. Okay. Question here: does the deposit act as a payment when I decide to go ahead with the agreement? Yes, it does. It is, you are paying the price partially, but it also functions as a liquidated damages clause, because if you decide to if you change your mind and don't go ahead with the deal, then you don't get it back. But yes, it is part of the price you are paying. Specific performance. Well, I gave you the example when you want the party to perform their obligation. You don't want money. Injunction is an order to prevent a party from breaching a contract. So let's say my neighbor and I, we have an agreement that no one will erect a wall to block each other's view. So my neighbor starts erecting a wall. So I would sue my neighbor and I would seek for an injunction order. I would seek an order from the court that my neighbor stops erecting the wall and blocking my view, because we have an agreement in this regard. So this is injunction. Accounting is when a company discloses their financial records and pay over profits. So let's say there's this fake goods distributor, and the owner of the goods, they would sue the company, and they would also seek for an accounting remedy, because they want to know what profits this fake distributor made, because they want this money for themselves. Quantum merit is payment for partial performance. So I am a construction company, I'm building your house. You breach the agreement. I don't want to build your house anymore. I don't want to keep on building your house. So because you breached the agreement, and you don't want to pay me, so I would sue you, and the order I would get in court would be a quantum merit, because I want to get paid for what I have delivered already, for my partial performance. Okay, so that's the quantum merit order. This is Latin expression. Remember that all those equitable remedies we saw here: rescission, rectification, specific performance, injunction, accounting, and quantum merit, they are discretionary on the judge. So the judge may decide to apply them or not. In some cases, the judge would say, no, I'm not applying those. I will award damages instead of any of those remedies. Okay? Or if any of these orders, they cause an undue hardship, or if the victim takes too much time to seek for them, undue delay, latches, they are not available either. Okay, so those equitable remedies are not available if they cause an undue hardship or if the victim takes too much time to seek for them. So question here, can that be tender performance even if performance of the obligation has already begun? No, tender of performance is you are willing, ready, and able to perform, but the other party refuses your performance. Quantum merit is different. Quantum merit is an order you seek in court. So again, I am the construction company, I'm building your house. You breach the agreement. Let's say you didn't pay me last month, so you breach the agreement. So I don't want to build your house anymore, so I'm going away. But I am still entitled to partial performance to everything I have done so far. So this is a type of remedy I would seek in court. Whereas tender of performance is if I came to your land to build your house and then you say, no, 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 you're not building the house or you are refusing my performance, then this is different. Is this clear? Okay. Okay, this is just for your reference. And yes, that's everything I wanted to share with you on chapter 9. So ending an agreement and remedies for agreement.